I'd like to welcome everyone to today's webinar, the top 10 GDPR myths and misunderstandings and how to defeat them. Thank you for joining us today. So let's go ahead and get started. At this time, I'd like to introduce speaker Scott Giordano, a highly regarded data privacy attorney with over 20 years of experience and currently a director at Robert Half Legal. Welcome, Scott.
Thanks for having me on board, Doug. I'm very happy to be here today. Looking forward to talking about all the misunderstandings, at least the top 10 anyway, that we can squeeze in here. And I do want to encourage everyone to send questions in as we go. So why this presentation? I've been involved in GDPR and privacy per se, privacy for the last 4 or 5 years, seriously, GDPR for the last 24 months or so. Even before the regulation was passed, I was following it. And what's interesting is it's really created its own mythology, just all kinds of things I hear every day because I'm immersed in this every day. Data protection is its own discipline. It's not just privacy. It's not just security. It really is a combination of both. It looks at protecting data holistically. And I think that's created a lot of misunderstandings and a lot of assumptions that simply are not true. One of the issues you're going to find with GDPR is that there were 3 parties that negotiated this in Europe, and as a consequence, there were some compromises that were made during the drafting process. One notably was the whole idea of consent, and was it explicit or should it be implied or could it be implied? And so you've got this vague notion of consent that it could be explicit, but it could be implied, which really didn't do anyone any good. Also, the English grammar was less than scintillating, not that U.S. laws are necessarily that great with English, but a colleague of mine, Phil Fisher, last week pointed out in one of his blog posts, one section of GDPR, and I won't read it for you all, you can read it yourself, but it just turns you into knots. And really, the grammar in here just in many cases leaves a lot to be desired, and it creates a lot of I think, opportunities for misunderstandings. And then finally, many assumptions are being made without anything in evidence. And if we have time towards the end, I'll go to my list of dishonorable mentions that didn't make it to the top 10 list. So without further ado, Doug, why don't we go to the next slide, and we'll talk about the first one. And these are not in any order, by the way. These are typically just I think, if anything, most often as I see them. One is that personal data is the same thing as PII. That is not true. I hear it all the time. PII is people just refer to that, at least on this side of the Atlantic, as personal data. They are not the same. And here's why. They look the same. But if you look at GDPR, I've highlighted 2 things here. One is this idea of an online identifier. This other idea of one or more factors specific to the physical, physiological, et cetera, identity of that person. Contrast that with US OMB, which is Office of Management Budget. This is one of the definitions of personal data, or PII, I would say, here in the US, and how they define it. And they look the same, but they're not. And so if you go to the next slide, Doug, I'll show you why. Okay. So recital theory talks about this idea of an online identifier. So it's something that's provided by an individual's devices, applications, tools, or protocols. So that could be an IP address, a cookies, RFIDs, all those fun things. Here's the problem with that is that think about the last 20 years. If you've got something that was made in the last 20 years, it's powered by electricity, it's not much of an exaggeration to say that it probably produces personal data because it produces things that are powered by devices, applications, tools, and protocols. So it expands the universe of what's personal data astronomically. And again, I deal with this every day. I work in Article 30 data inventories every day and work with clients, and they're shocked at how much personal data they ultimately have because of the nature of it. Also, this concept of this physical, physiological, etc., cultural, social identity, I mean, this concept is so elastic, it could mean just about anything. And so that's a huge problem in the sense that it means that so many things could be personal data that maybe on their own you wouldn't think they would be, but in conjunction with other things, they are. So the net of it is that personal data is not PII, but it's a big myth that it is. So if you go to the next slide. So how do we defeat this? Really what you have to do is look at the data elements involved and really dig into it. I see folks that say, this application deals with employment data or deals with medical data or deals with this. They don't really dig into the individual data elements. Well, okay, well, what does that mean? Does it include a social security number? Does it include genetic data or biometric data? What kind of data? you really have to dig into this and ask if a reasonably competent bad guy could exploit it, or a reasonably competent good guy, or incompetent good guy, I should say, could mess it up. It's probably personal data. And I'll give you a great example is GPS data. You could have a couple GPS locations about a person, and it's not really going to tell you a lot. But imagine getting a week's worth of someone's GPS data and nothing else. If you had just that and nothing else, you would know everything about that person because you're getting an idea of all the places they go. People are creatures of habit. So you're going to know just about everything that you want to know about that person just by virtue of the places they're going, when they're going, how long they stay, all of those things. It's amazing how much you can learn. So as a consequence, quantity has a quality all its own. And this is something I tell my clients every day, that just one element of personal data can be exploited. And it can be exploited by people who know what they're doing, or in some cases, people who know what they're doing, but innocently perhaps share it with others or share it with other applications on your smartphone or on your account or what have you. So the net of it is that you really have to take a very jaundiced view as to what could be exploited as personal data and assume that that's not PII, that goes far and beyond PII. Doug, I'm going to do a full stop. Any questions or comments thus far? So next one up is GDPR only applies to EU citizens. I hear it every day. Folks, if you leave nothing with nothing else today, the word citizen, the word resident does not appear in the regulation. Okay, what it says is the processing of personal data of data subjects who are in the union. Okay, so specifically for our purposes here, if you're processing it, you're established there, then it's obviously easy if you're to say that you're held accountable by GDPR, but suppose you're not. Well, guess what? If the data subjects who are in the four walls of the EU, you're processing their personal data, you're subject to GDPR. So it doesn't apply just to EU citizens, just to residents. It could be tourists. It could be their people that are refugees. It could just be their people that show up by accident. It doesn't matter. If you're inside the four walls of the EU, you're an EU citizen. Okay. Are there exceptions? Yeah, you can make the argument that people on military bases that are foreign, like U.S. military bases in the EU, it may not apply. Okay, but put that aside. That's really tiny. Everything else is fair game. So don't worry about someone whether they're a citizen or not. If they're inside the four walls of the EU, then they're fair game.
A couple of questions around the same topic. So quite a few people are asking for examples or more clarity around the difference between personal data and PII.
Okay. PII tends to be a narrower definition in the sense that online identifiers that I just described could be PII, but it's not something that was really emphasized by U.S. law. If you look at U.S. law, they talk about things like, for example, in California, you can have an identifier like a bank account that has to be linked with a first initial, last name, or a bank account linked with some other identifier like a password. The idea is that they make it a little bit less narrow in the U.S. than in the EU, where just an identifier in and of itself, full stop, GPS data, IP data, MAC addresses, RFID, full stop, personal data. That's it. So the concept is just wider. Also, this idea of I cited earlier about the cultural identity of someone. Unfortunately, I have no idea what a cultural identity is, but I can tell you that the regulators are going to figure it out, and it's going to be wider than our idea of such a thing in the U.S. The net of it is that you're going to find just much more items, if you will, much more information turns out to be personal data in the EU, and therefore is in scope, which means it needs to be in your article theory database and all those fun things. I wish I could be more specific than that, but I can tell you that generally speaking, when in doubt, it's personal data, and that's the rule I go with, and that's what I analyze for my customers and give them that perspective. So let's go to the next myth, misunderstanding, or mistake. So how to defeat this? Ask yourself, when was the person in question inside the four walls of the EU? Okay, so if it was when the transaction took place or the relationship started, yeah, you know what? It's pretty much a good bet person's an EU data subject. Okay. But suppose it was after the transaction relationship started. Maybe they were visiting the U.S., they downloaded your app in the U.S., and then they went back to the EU, and you're still processing their data in the EU. It could be a GPS thingy or something like that. Well, here's the problem. You're now processing data, personal data of an EU data subject on equipment in the EU because it's on their iPhone or their Android device, whatever it is. So in principle, you're now hooked into GDPR. Congratulations. So that's an issue, and it's an issue that I have a lot of clients dealing with right now. Okay, suppose that the transaction took place in the EU originally, but the person moved. Maybe they're an employee now in the US. Maybe they're retired and they went to South America, they went to Asia, wherever it is. What happens to that pool of data? Are you still using it as the processor? That, if you're relying on that original pool of data, presumably, even if they're not in the EU anymore, that data still is covered by GDPR. Even if you move that pool of data over out of the EU, that originally was personal data, and just making a copy of it and putting it on a server somewhere else doesn't take away that character. The net of this, again, is that you can't just assume that people have to stay inside the EU in order for that personal data to stay personal data. So really have to think about what happens when they leave the EU, even if it's just temporarily. Okay, Doug, let's go to the next one. Okay, so GDPR only applies to EU companies. I'm still hearing this even today, and there's really three good ways to get hooked into GDPR. One is you are processing data on equipment in the EU, meaning someone's cell phone, their laptop, what have you, or a server that's in there in the EU somewhere. Okay, even a cloud server, if it's in the four walls of the EU, it's still in the EU. Also, offering goods or services. This is Article 3, Sub 2. This is what will hook most people, most organizations that don't already have a physical presence in the EU. So if you're offering goods or services that EU data subjects, guess what? You are now caught up by GDPR. Also, if you're studying the behavior, okay, so if you're doing big data, and it doesn't have to be very big data, if you're just studying the behavior in a way so that you're trying to predict what actions they may take. It doesn't have to be in an economic context, could be in a political one. I know that's been very hot in the news. I'm not going to dig into that, but the net of it is that studying the behavior of EU data subjects and predicting their behaviors, however subtle it might be, is going to hook you into GDPR. So it's not just applicable to EU companies, EU-based companies, and it's applicable to anyone in the world. So this is another thing that's interesting. We tend to think of this as being very problematic for the US. It's problematic for the whole world. So if you're an operation, say that you're one of the big automakers in Japan, and you sell into the EU, and you sell goods or services in there, and you offer them through your websites and all those fun things, guess what? You're processing the personal data of EU data subjects, especially given all of the electronics that cars have and all the things they process. There's so much of that that's personal data just in and of itself. So the moral of the story is it applies to just about every company that has a connection with the EU. And if we go to the next slide, Doug. Okay, so how do you defeat this? You really have to look at these hooks very broadly. Think about the goods or services you're offering. I have clients at universities. They're advertising into the EU for EU data subjects, students to come over to the US to matriculate, okay? Well, here's the problem. If you're setting up a relationship with those folks over there, if you're exchanging data over there, maybe they're applying, presumably they're applying to your university while they're over in the EU. You're processing their personal data on their equipment. They're emailing you their CV, or they're emailing you an application, or whatever it is, or their personal statement, all that stuff that they're emailing you or they're uploading to your server, whatever it is. Guess what? That's all personal data. So now you've got this blob of personal data, as I like to call it. And now the question is, great, the person comes to the US, all that stuff was personal data. It doesn't suddenly become not personal data because they showed up on US shores. Same thing for hospitality. Okay, if you're advertising over there and Europeans start showing up at your hotel, you can't say the relationship you established with them over in the EU doesn't count anymore. Okay, if you're recruiting, you've got a server over in the EU and you're asking people to upload their resumes. Well, guess what? You're processing their personal data on equipment in the EU. So it goes on and on. Okay, studying the behavior, profiling, as I said earlier, not just for big data companies. Really, anyone's trying to do this. Predict behavior, use big data, analyze the data. Maybe you bought the data from a third party. Now you're hooked with the GDPR, okay? Just having a website that's available to the EU data subjects, not enough. But if you do more than that, if you put up websites in a local language, if you offer goods or services in local currency, then you're more likely to be considered hooked into the EU, and therefore GDPR applies. It's not tough for the GDPR to apply to you. So. Doug, any questions or comments on that one?
Yeah, there's a few comments and
Sure.
Few questions. So goods and services includes banking, e-commerce, retail, etc.
Mhm.
Obviously not limited to those three. And is credit card data being considered within the scope of the GDPR? Say, for example, a EU resident travels to the US and uses their credit card.
Well, it's a great question. Where are they using it? Okay, because if they're using it at an institution that offered goods or services into the EU and is now offering, essentially, they're going to have a credit card processor on the back end that's going to be processing that. You can make a very good argument that now they're captured by GDPR. That credit card data, if you will, personal data is captured by GDPR. Absolutely. Now, let me contrast that with something. If you didn't advertise in the EU, if some just EU person just shows up at your store, your mom and pop store, and uses the credit card, is that personal data? No. Okay, in my view, it's not. It really depends on, is it fair to hold you accountable to that person's data because you established a relationship with them over in the EU? That's the test I'm using, because we're still waiting for the Article 29 working party to really give us a lot more guidance, but we're just trying to look at what's reasonable under the circumstances.
If you're based in the US and advertise in the US and someone from the EU comes over and uses your services, then are you under GDPR?
In my view, no. If someone from the EU just shows up at your store, your institution, whatever it is, you have a website and that's pretty much it. You're not going out of your way. You're not offering goods or services by doing really any effort to offer those into the EU, then it's hard to argue that you're captured by GDPR.
Does Google Analytics, is that included? For example, a retail store tracking site visitor behavior?
The answer is yes. I consider it. All my clients that use the Google Analytics, we presume that it's captured under GDPR. Okay, EU authorities can't enforce GDPR against U.S. companies. Okay, well, actually they can. And here's how they're likely going to do it. One is that they've got this thing, Article 27, which we're still a little vague on. It's the idea that you're going to appoint a representative and in the EU, and they're the ones that are going to get it if you do something wrong, okay, and the EU data protection authorities, the supervisory authorities, want to levy or punish you, they're going to go punish this representative. So, of course, it raises the question, well, who's the unlucky person that's going to be this? Answer is we don't know. But this is the idea that they're going to be able to enforce against U.S. companies. Also, I'm sure all of you remember Safe Harbor, and what happened is that the FTC didn't do a terribly good job back then of enforcing the privacy laws that were really required of anyone importing data from the EU to the U.S. As a consequence, Safe Harbor was torpedoed. Okay, and so then Department of Commerce had to go and completely renegotiate everything. It was a lot of work. And now they don't want to see that get torpedoed as well. So you would not be surprised at all to see the European data protection authorities, the supervisory authorities come over and lean on the FTC to lean on U.S. companies that are abusing personal data. Okay, can't prove it, but I would not be surprised to see it because all this is very political. That's one of the great lessons I learned when I got into multinational privacy is that it's a lot less legal, a lot more political when it's cross-border. If we go to the next slide, Doug, we'll talk about this in a little more detail. Always ask, is it reasonable to assume that data subjects are going to make GDPR-related demands? Okay. If so, EU supervisory authorities will likely enforce. So think about if you have employees in the EU. All right. If you have employees and you get into a fight with the employee, you know for sure they're going to do a DSAR, data subject access request. They're going to say, erase every electron you have about me. And then when that doesn't happen, then they're going to complain to the DPA. So you can bet your next paycheck that's going to happen. Also, if you have customers that are angry at you, they're going to do a DSAR and then they're going to do the same thing. So you can just bet that you're going to get a lot of vindictive enforcement actions just by people that are angry with you because they can do so. And don't assume that anonymization is going to save you. I talked to a lot of folks that say, oh yeah, we're going to anonymize all the data. Well, here's the problem. It's not terribly difficult to de-anonymize data with the tools we have nowadays. So don't presume that just because you've anonymized it that you're in the clear and you can do whatever you want. Because if you can de-anonymize it in some fashion, then it's not really anonymous. And it doesn't take a lot more brain power nowadays to do that. It's amazing what big data technology can do, and it has done in a short time. So if your processor is hacked, say that you're an American company, but you have someone in Europe processing all of your EU personal data, you can assume that politically you'll be pulled in because ultimately you're going to be held accountable to whatever they did wrong. So keep that in mind as well. That's also a principle that's enunciated in Safe Harbor. I'm sorry, in Privacy Shield. It was also in Safe Harbor as well. With that, Doug, let's go to the next one.
Sure, just a few questions. Yeah,
sure,
so if my company is based in North America and I provide a software solution which is GDPR compliant, as an organization, is my company required to be GDPR compliant as well?
No, I mean, if the tool itself is GDPR compliant, then you don't necessarily have to be. You have to ask yourself what personal data you're involved with, though. And here's where this usually comes into play. If you're remoting in, okay, to go view the data, you're really reviewing the underlying infrastructure, but you're seeing the personal data as well. That's when you're most likely to be captured. Is that you've got a customer, they've got their software running on some server in the EU, and you've got to remote in to do troubleshooting, or you've got to remote in to do engineering work, whatever it might be. Problem is now you're seeing all that personal data, and now you're captured by GDPR. That's the hook. That's what usually gets the software companies. That's been my experience for at least the last 4 or 5 years.
But as the organization, if they have employees, for example, that are EU citizens, or the data subjects are EU citizens, the company itself would fall under the GDPR compliance requirements, correct?
It would, because you're going to be, you have to see their personal data at some point. There's no other way. You're going to be seeing it, and you're going to be processing it. Even if you process it over in the EU, you're still processing personal data on equipment in the EU. You're going to be seeing it, and you're going to have the ultimate ability to do things with it. You're the data controller. Okay, if you have the last word on the data, you're the data controller, and so as a consequence, you'll be captured by GDPR as well.
Great. A couple other questions. Does GDPR affect when you provide a service to a company in the EU?
Does it affect when you provide it? I'm not sure what they mean by when you provide it. I mean, if they mean, post May 25th versus now, it doesn't apply till post May 25th. However, the Data Protection Directive applies right now anyway, and they have a lot of GDPR related elements anyway. So I'm not quite sure about the question, but they can always email you back if you want, Doug.
Okay, understood. But I understood the question asked, if you provide a service to a company located in the EU, so as a data processor, perhaps located in the US.
Yes. Are you captured by GDPR? Absolutely. You're processing EU personal data. You're a processor, and you're going to be held to the same standards that the controller is, essentially. Also, remember, you're signing a model contract clauses agreement, which lists all the things you're going to do. And so that data transfer agreement is pretty lengthy. Also, you're going to have your Article 28 requirements that someone's going to add to that data transfer agreement, which is all your processor requirements. So indirectly, yes, you're being pulled into GDPR, but you're still being pulled in.
So what if a U.S. citizen travels to the U.S. and uses a credit card at an ATM owned by an EU company?
If a U.S. citizen uses a credit card owned by an EU company, to the degree that the data is processed on EU equipment, okay, that data is going to be subject to GDPR. So if for some reason you're a U.S. company, you're processing U.S. data on a server in the EU for some strange reason, that data is covered by GDPR. And so you're going to have to adhere to all the fun things the GDPR requires, like data subject access requests and all those other things as well, and security measures, et cetera, et cetera.
Great. One last question. I know you have a lot of content to cover. This is a great question. Will the U.S. courts back up actions or fines against U.S. companies in disputes?
Oh boy, that's a great question, because what's going to happen is that I'm sure someone's going to challenge this. I know someone challenged the FTC. I believe it was a hospitality company, challenged it about, 3 or 4 years ago and lost. So the net of it is that I wouldn't be surprised if a company did challenge it. I'm very curious to see how it would go, because without a treaty or a formal agreement, unless they're a subscriber to Privacy Shield, let's assume they're not, then it's very interesting. At this point, I don't know. Okay, let's do the next one then. One of my favorites, if we have an ISO 27K cert, we're GDPR compliant. No, you're not. Okay. And here's why. ISO 27K is great. I love it. I love all certs, quite frankly, but ISO 27K is great. Here's the problem. It addresses Article 32. Article 32 is one article of GDPR. It also partially addresses Article 25, which is data protection by design and by default. Here's the issue, is that the controller and the processor shall implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk. And if you look at sub 2, it's addressing risks that are presented by the processing. That's great. So you're addressing those risks, and the fact that you're using ISO 27K or whatever cert you're using is great. That's just Article 32. That doesn't cover everything else. Half of Article 25 is data security, okay, and so that's great. The other half is data minimization. So presumably, if you're good with Article 32, you're good with that half of Article 25, but that's it. There's nothing else. So keep that in mind, is that yes, that cert is great, but that covers just that article. And if you go to the next slide, Doug, I'll dig a little deeper into this. So you've got any control set you happen to like. It could be NIST 800-53 or -171 or what have you, or COVID or whatever your favorite control set is. It's still going to address just Article 32 and partially Article 25. Think about all the other requirements that you've got. You've got Chapter 3, data subject rights, so DSARs. Article 30, records of processing, which is hugely important. Your Article 28, third-party requirements, your cross-border transfers, all of that, that's all things that you're just not going to find in ISO 27K. It wasn't designed to do this. Okay, it's a different animal. Also, here's the problem with ISO 27K is you have your statement of applicability. What servers are applied by this? What servers are included in this cert? If the server that's processing the personal data is not included in the cert, then you're out of luck. So that doesn't help you very much. So if you go to the next slide here, we'll show you how to get around this or how to deal with this. One, go to your privacy and security risk assessment, your risk catalog. Hopefully you've done one. If not, then probably now's a good time to get started. Your Article 30 inventory, crucial. You want to look at all the processes and get an idea of what the security measures, either point security, meaning your identity access management, all those things, your firewalls, if it's a third party, what's their security looking like? And then ask yourself, is the cert in place? Does the SOA include the processing that you care about, processing that has personal data? And are the controls addressing the Article 30 processes? Great, then you've got Article 32 met and a portion of Article 25, and that's it, okay? And you have to do it on a process-by-process basis because you never know. Suppose you have a paper process for whatever reason that you're doing. ISO 27K probably not going to help you much there. I could be wrong, but probably not going to help you. So you have to go through the processes one by one and get an idea of what kind of security is in place. If this particular control set is applicable, great. Then you've checked that box and you can point to it and say, yes, this is how we're protecting it. If you can't, then even that doesn't work, and you're going to have to find something else to protect that process. That's why ISO 27K cert is great, but it's not enough. Questions, comments, Doug?
Yeah, it's good to mention there's a gap analysis that needs to be done to implement both the ISO 27K certification as the GDPR.
Yes, excellent. Excellent. Yes, and I work on gap analyses all the time. And yes, every single control set, and I've worked with a few, all incorporate some kind of assessment or audit and gap analysis, and then a remediation program. So yes, thank you for sharing that. That's absolutely spot on. Privacy Shield compliance equals GDPR compliance. No, it doesn't. Okay. Privacy Shield is great. I'm not disrespecting it. It's a great mechanism, but it's a data transfer mechanism. So it's great for moving data from the EU to the US or from Switzerland to the US. And that's it. Okay, you cannot use Privacy Shield to move this data, your EU data, to say Japan, for example, or Russia, or the Middle East, or anywhere else. It's got to go to the U.S. That's it. So it's good for that, but it's not really good for anything else in that context. And the principles are good. If you go to the next slide here, you'll see all the principles that it enunciates. And if you are into privacy, you've probably seen these principles before. It'll be notice and choice and accountability and all these fun things. These are all great. And I've done Privacy Shield projects many times, and these are all great because you're really doing a lot of great groundwork for other compliance regimes that you might be doing. So have a lot of great things to say about it, but it is not GDPR. And I'll give you an example. If we go to the next slide. Okay, it's not meant to be a replacement for the regulation or the directive, for that matter. I mean, the directive, yeah, it's not nearly as big as the regulation, but still, it's not even a replacement for that. The regulation's got 173 recitals, 99 articles. It's massive. It really is. I mean, it's just the amount of work that went into that is massive. Okay? It requires a data inventory, which I've been talking about a lot on this call because they're so important, and I don't think they're getting enough attention. The right to erasure. You have your other Chapter 3 rights. So your right to access, your right to object, all these fun things, that's all part of GDPR. Your 72-hour breach notification, part of GDPR. So all of these things are very important. GDPR is going to take a bigger position, a bigger real estate, whatever you want to call it, in the privacy context than Privacy Shield will be. Also keep in mind that the e-privacy regulation is on the way. This is the regulation that addresses cookies and emails and marketing and all those fun things. That is coming sometime this year. So if you thought you were done with privacy, nope, this will be on the way for enforcement next year. Also, Privacy Shield is a great way to think of as or to be thought of as a GDPR on-ramp. That's what I was telling my clients 18 months ago. That's the best way to think about it. In some cases, they took that to heart. Some cases, they didn't. But that's a good way to think about it. It's in some ways a microcosm or on-ramp to GDPR. So that's Privacy Shield. Comments, questions on that one?
Not regarding Privacy Shield, but there's a few questions asking if a company does not on-ramp or does not do data inventory mapping or know where their personal data might reside on their networks or data processors, and they're in violation. So if they get a GDPR violation notice, how much time do they have to respond, and how do organizations, or how should they expect to respond?
Well, I don't know what the turnaround requirement is for if a DPA makes an inquiry. Typically, you should think about it in the way you would any government agency. I mean, if I got a letter from the IRS, you bet I'd be on the phone immediately. And the same thing goes for any other regulatory mechanism. So the short answer is they're probably going to use the without undue delay standard, because that's a standard that's used throughout GDPR. So yeah, as net of it is that if you get a call from the ICO, for example, it's probably a good idea to call them right back, or a letter. I was very interested to see last week. I saw some photos of the ICO, the Information Commissioner's Office in the UK, with the same kind of jackets that they wear here at the FBI when they were doing a raid on someone. So they take this stuff seriously, folks. I really don't mess with the privacy folks in the EU. They don't mess around. So yeah, I can't give any more advice than that, unfortunately.
Understood. So there's a lot of research published by Forrester and Gartner analyst firms saying that anywhere up to 80% of organizations are not going to be compliant by the time of the deadline. What if an organization refuses to comply with GDPR and they are in violation? What sort of punishments could they expect?
Well, the scariest one is an injunction. I know sometimes we talk about people getting fined, but really an injunction is far scarier, especially if you have operations in the EU. They can simply shut you down and say you're to stop processing personal data, otherwise the guys in the blue jackets are going to show up and shut you down. So that's a much scarier prospect, in my view, than even having fines, because you can potentially litigate the fines, but if you get an injunction, you're out of business, at least in the EU. If you're processing data only in the U.S., even though it's of EU folks, then you have the whole political issue of the ICO or some DPA coming to the FTC and saying, "Hey guys, you need to knock this off." And the FTC likely will comply with helping them, because again, they don't want to run into any trouble with these folks. So that's my personal view. I can't prove it, but we'll see what happens after May 25th.
Great. If a data processor is not planning to be compliant for GDPR and they work with data from a U.S. firm that has EU data subject data, is that third-party data processor required to be a GDPR compliant?
If you're a third-party processor and you're processing EU personal data, you're required to be compliant, full stop. Okay, the GDPR applies essentially equally to processors as it does to controllers. So that's going to be an issue. If you've got EU personal data and you presumably acquired it legitimately, and you're going to now give it to a third party to process, then that processor is going to rely on you to have a legitimate legal basis to process the data in the first place. So they're going to be relying on you, and so if there's any issues, they're going to come back to you and say, "Hey, we relied on you and you didn't get it right." So then from there, litigation obviously will probably be the result. So yeah, that's the best way I think summarize it.
Great, thanks. One last question. How
Sure.
is a notice delivered?
How is a notice delivered? I have never received one from a DPA. So I couldn't tell you. My guess is going to be like anything else you get from the IRS or any other U.S. agency, is that they will probably mail you something, they'll fax you or email something to whatever number they can get their hands on. And if they don't hear back from you within a certain time, then they'll probably pay you a personal visit. That's my guess how that would probably work. If otherwise, they may even engage the courts and have the courts start with an injunction just because they haven't heard back from you. Again, these are all guesses. I've just never gotten that kind of letter from a DPA. Let's go to the next slide and see what we got here. Okay, so we did that. Yeah, I'll wrap this up real quick. So Privacy Shield compliance, do your Article 30 data inventory, do your assessment. And I think we mentioned this a little bit earlier. Do your assessment to your ability to meet the regulations requirements, do your gap analysis, and put together a plan. A plan is not the same thing as being compliant, but having a plan of action and milestones, a POAM as we call it, is very important, because if worst comes to worst, you want to at least be able to show that you've got a plan going, that you're actively pursuing it. Will it get you out of trouble? Probably not, but at least it'll show that you're on the right track. See, okay, if we need a DPA, we need a DPO. So if we need a DPIA, Data Protection Impact Assessment, we need a DPO. Very common misunderstanding. And it's simply because they being the GDPR, use very similar language. So DPIAs are really revolving around high risk to rights and freedoms of data subjects. Okay, I got that. If you go to the next slide, though, you'll see that they dig down into much more specific things. One is systematic extensive evaluation, automated processing, things that produce legal effects, okay, which we're not quite sure exactly what they mean by legal effects. Or processing on a large scale, special categories of data. So think about if you're a medical institution, or you do criminal background checks, or you perhaps are doing something that's related to any of those kind of things. That it's fairly easy to say, okay, yeah, it makes sense you need a DPIA, and not surprisingly, you probably need a DPO, as we'll see in a minute. Here's the problem. If you go to the next slide, though, DPO categories or requirements are a little bit different, but they're close enough that they're going to cause misunderstandings. So on the next slide, we'll show you how DPO standards are. Okay, one is if you're a public authority. Put that aside for the moment. I'm presuming you're not a public authority. But if you do regular or systematic monitoring of data subjects on a large scale, and again, we don't know yet what a large scale exactly is, but regular systematic monitoring, think if you're a managed security services provider, pretty much a good bet you're going to need a DPO, even if what you're doing is not ultimately presumed to be high risk, okay? If you're processing data on a large scale of special categories of data, this is where you could have a situation where you need both a DPIA and a DPO, because you're processing on a large scale special categories of data, like Article 9 data, medical data, for example. And so almost certainly if you're a medical institution, you're a clinical research place, yeah, if you need DPIA, in that case, you're probably going to need a DPO as well, because there's enough overlap between the two definitions. But just because you have something that's high risk does not mean you need a DPO necessarily. You really need to go and dig in and see whether you need one. What you want to do is ask yourself, what's your core activities? Not things that are incidental to you, but what's your core activities? So if you're a hospital, security provider, credit reporting agency, I know that they're not terribly big in the EU, although I guess there were some EU data subjects that were on the Equifax breach. If you're a big data company, okay, all these organizations, yeah, they're good candidates for DPOs, but just because they're good candidates doesn't automatically mean you need one, but you'll have to go and do the dig deeper. So as a consequence, those are good candidates, but don't assume you need to have one necessarily. Go dig in. If we go to the next slide, really what you want to do, okay, let's back up here for a second, Doug. So as a practical matter, just because you need a DPIA, you're going to go through every single process you've got. So go to your Article 30, go have a look at all the processes, ask yourself, is there a danger to the rights or high risk to the rights and freedoms of your data subjects? Let me just give you a couple quick counterexamples, and then we'll go on to the next slide. So you remember the whole Ashley Madison site that was hacked, okay? Great example of processing that was extremely high risk, because the potential damage to the patrons was extraordinarily high, and in many cases it turned out to be the case. Office of Personnel Management here in the U.S., high risk processing because the nature of the data involved and the fact that it was hacked, not surprisingly. Credit reporting agency data, so like Equifax, again, a very high risk processing because of the nature of the data. Those are all great examples of high risk. Do they need a DPO necessarily? No, they don't. So you really want to have to spend some time looking at the particulars before you say one way or the other that you need a DPO. So with that, let me go on to this next one because I get this a lot. We're a low risk target for enforcement. And I alluded to this a little bit earlier. Everyone's a target, okay? Look at the DPAs themselves. They're getting their funding from fines. And the Irish DPA was great. Helen Dixon, she cited this last week. We don't bear any resemblance to the authority in 2014. We've more than tripled inside. We've more than quadrupled our staff. They've done that for a reason, okay? Because they're getting funding from fines. So if you are a high risk example, you're a data processor, okay? You're expected to be an expert, basically. If you're a B2C company, you expect angry customers to want to be vindictive. If you've got companies with EU employees, expect ex-employees to want to be vindictive. They're all going to be potentially calling their DPA. If you're a company that suddenly becomes unpopular, okay, very easy to find those in the news today, now guess what? Someone's going to call the DPA and start an investigation. Go to the next slide, Doug.
Scott, are there any special categories, for example, nonprofit organizations or cities, et cetera? Are there any special categories, or is anybody excluded potentially?
No one's excluded. I'm so glad you asked that. One of the honorable mention items or dishonorable mention items I have for you guys is that there's a small business exception. Sometimes I hear that. Oh, we're a small business. We're not covered by GDPR. Wrong. You are. Everyone's covered by it. Every government agency, every nonprofit, everyone's covered by it. There are functions that are not covered, like for law enforcement activities, but government agencies, nonprofits, you name it, everyone's covered. I don't care how small you are. Okay. Again, these are more all high-risk examples. We can go to the next slide on that. So how to defeat? Do your own worst-case scenario. Do you have a legal basis for everything? I think this is probably the weakest link in the chain I've seen in the last 18 or so months, is that every single process has to have a legal basis, whether there's a consent, there's a contract involved, it's in the legitimate interest of both parties to do this, whatever it is, you've got to have it, okay? Chapter 3 rights, being able to do a data subject access request. I guarantee you're going to get them, and you've got to be able to respond to them. That's a worst case scenario. Is your privacy notice making unrealistic promises? Oh boy, you are an absolute target. If you say things you're doing, you're not really doing them, don't put it on your privacy policy or your privacy notice, really. Otherwise, you're going to get in trouble. And breach notification, now breach notification is mandatory. It's going to be a great way to have DPAs pile on and let you have it. If something bad happened, worst case scenario, what would a DPA say? If it's not good stuff, then you're a high risk. So I really want to just try and apprise everyone, don't presume you're a low risk. I think everyone out there is at risk. Let's go to the next one, Doug. IT or legal or compliance or fill in the blank has got this covered. No, they don't. Okay? GDPR compliance touches all or nearly every department, every line of business. If you're going to be truly GDPR compliant, you're going to have assistance from legal, both inside counsel, outside counsel. You're going to have HR, your IT and IT security. Basically, everyone in the company is going to be involved in some form or fashion in GDPR compliance. So don't presume that IT's got this covered. When I hear that, I talk to someone and say, oh yeah, IT's got this covered. No, they don't. You may think they do, and they may think they do, but they don't have it. Now, let me give you some examples. If you go to the next slide, Doug, you'll see some things to ask. So say, for example, that you're the department in question saying, oh yeah, IT or legal or compliance or someone's got it. Ask them, where is the Article 30 data inventory? Is there a legal basis for everything? That'll pretty much stop the conversation right there. How are you going to address Chapter 3 rights? Like right to be forgotten, for example. How are you going to delete all that data? Who wrote the privacy notice and when was it written? Probably 10 years ago. What's your breach notification plan? And sometimes people say, oh, well, we have an incident response plan. Well, that's not a breach notification plan. Okay? Breach notification is about notifying affected parties. It's not about all the internal things you do in incident response. So as a consequence, assemble a data protection committee and get working on this, because I can tell you, if X department's got it, no one's got it, because no one department can do this. Questions, comments, Doug, from anyone?
Yeah, a couple of questions. So okay. How do I provide a privacy notice to use data subjects that this particular company sends invoices to?
What you can do is have it on your website and then have a link in the invoice saying that, and presumably that you've established a relationship ahead of time, so that either that person's created an account on your billing system and you can have the checkbox there that says, I've read the privacy notice and I've seen it and I'm good with it, etc. I accept the terms, or I accept the, I consent to using my privacy or my personal data, or otherwise finding a way to create a link in the invoice to that privacy notice that's on your website. If you don't have a website, you can just put it in the bottom of the invoice, for example. I know that in many cases when I was working previously, I was with another company, we would just put a privacy notice on a placard in an office so people could see it when they come in and say, okay, I know I have to get screened or whatever for this particular position, etc. So the idea is at the point of data collection is when you want to give them the notice. And you may have to be creative when how you give it to them, but as long as you're giving it to them, that's what's important.
Great. What if you're a US-based company or data center, and that data center, well, let's say you're a US-based company and your data center says they're not a controller or a data processor, and that they're not impacted or involved in GDPR, even though they contain their databases may contain EU citizen data at their location. Are they under scope for GDPR compliance?
Sure. If you're processing the personal data of EU data subjects, you're hooked into GDPR. You have to be compliant with it. There's no ifs, ands, or buts. So, and in many cases, companies have gotten this data over years and years and years and never really thought twice about it. Now, suddenly they've got all this data. And think about marketing agencies or companies that sell marketing data. They may have gotten all these email addresses over years and years and years, or they may have scraped them from some site on the internet or what have you. All that has to be legitimized, otherwise you can't use it anymore. Okay, because you need a legal basis for everything. And I say that a lot, but people don't really appreciate it until you look at a specific process and say, well, how is that legal? Because I can tell you the European folks are going to ask you that same question for everything. How is that legal? You have to be able to answer that question. If you can't, then you're in trouble. So yes, that site or whatever you just mentioned, the data center, it has to be a GDPR compliant. And so they may find out the hard way, but that's how it goes sometimes.
Got it. Thank you.
Okay, let's do, we'll just get retroactive consent. Oh, no, you won't. You can't email someone to ask if it's okay to email them. So this is back to the thing I just mentioned where you may have a database full of emails. And now you say, you know what, we never got consent for that. Can we email this person to get consent? No, you can't. Information Commissioner's Office fined 2 organizations, one called Flybe, another one called Honda, one we're all familiar with, because they did that very thing. Now, the fines weren't humongous, but remember, this is pre-May 25th. So as a consequence, you're going to see e-privacy regulation come on board, and that's going to be massive. It's going to be basically GDPR, but for marketing. So in the future, that's going to be an issue. So no, you can't just email to ask someone if it's okay to email them. So yeah, no retroactive consent. So that, of course, raises the question, what can you do? If we go to the next slide, you have a couple things you can do. It's not going to be easy to dig through this. Look at the original nature of the consent. Was the consent good enough to begin with? So you may have to do a little forensic work there and find out how you got the email in the first place. Do you have a contract with the data subject? The contract may govern when you can send them updates saying, hey, we'd like your consent. Contract itself is a basis for processing. So potentially you could fall back to that if consent fails. And I say potentially. I know the Article 20 Working Party isn't in love with that idea. You can update your privacy policy and cite the updated privacy policy, privacy notice really, in your updated terms of service so that when someone goes to the site, they see the updated terms of service and they're forced to acknowledge it. Otherwise, just discard the data. It's not worth being fined. It's too easy to get fined over something that you probably may not even need anymore, and frankly is probably out of date. So retroactive consent, no good. Let's go to the next one. I think maybe at number 10. Oh yeah, we just finished number 10. So a couple dishonorable mentions, Doug, and then we can take some questions if you like. There's going to be a post May 25th grace period. No, there's not. Okay, we're in our grace period right now because remember this law was passed 20 months ago. There's no small business exception. We don't need a privacy policy. I've heard this one. It's disastrous. Yes, you need a privacy policy. GDPR doesn't say you need a privacy policy. It says you need controls, organizational and technical controls, a privacy policy, a security policy, acceptable use policy, breach notification policy. These are all policies. They're all controls. So yes, you do need a privacy policy. We don't need a data inventory for internal applications. We've got RSA Archer, or we've got some crazy database. Those tools are great. I'm sure that's awesome. You still need a data inventory. You can't rely on that in an emergency to say, oh, we're going to go to Archer and we're just going to run a search here or whatever it is. It wasn't designed to be an Article 30 tool. It's just not. I'm sure it's great for what it does, but you still need a data inventory for your internal applications, full stop. We don't need a data transfer agreement. I hear this sometimes. Oh, because we're sending the data to Canada, we don't need a data transfer agreement. Well, here's the problem. Canadian privacy law is adequate under EU standards, but only for organizations that are subject to PATA, which is their standard. Not all organizations are subject to that. So it means you're going to have to still have a data transfer agreement anyway. Regulation doesn't apply to government agencies. Yes, it does. Doesn't apply to transactional data. This is this idea that if someone just creates data on the back end of a server, somehow that it's not real data. It is. Excuse me. So yes, it does apply to transactional data. And then finally, the regulation requires encryption. No, it does not. It loves encryption. It does not require, it also loves tokenization, what they call pseudonymization. It loves it, but it doesn't require it. Those are my dishonorable mentions. Doug, happy to take questions in the 4 minutes we've got left.
Sure. So if you had a crystal ball, what is the expected tolerance among EU citizens for this regulation? And then the second part is, what is the expected tolerance by the DPAs?
I would expect to be very low tolerance on both parts, in the sense that they're going to be expecting you to be able to fulfill its requirements in full on May 26th. Again, because we talked about earlier, there's a lot of money to be made for the DPAs, and many of them are funded just by fines. So you can expect very low tolerance for violations.
Let me see, quite a few questions coming in. Are internal company account IDs considered personal data?
Potentially, yes. Employee IDs are a great example of that, because you can hook employee IDs and connect them with other databases within the company. So they are. Our other ones, it's going to look on a case-by-case basis. I would use the test I enunciated earlier, which is, could a bad guy exploit this, given just a reasonably competent bad guy? If the answer is yes, it's probably personal data.
Great. I'm just going through the questions. Sorry for the delay.
Sure. It's okay.
I'll just go ahead and read this question and see if it makes sense to you. Through the use of pseudonymization, what articles, if any, can be removed from scope?
Well, none, in the sense that pseudonymization is not anonymization. Pseudonymized data is still personal data. It's better protected than it was before, and that's great. I mean, tokenization we're all familiar with. That's another species, really, or another name for pseudonymization. I think it's great, but it's not going to take that data out of scope. Only if it's truly anonymized, meaning that you can't turn it back into identified data, would it take it out of GDPR.
Got it. So assuming I provide a managed security service to a client who's located in the EU by VPN, if a data breach is to occur, which results in customer data leakage, although I will be partly to blame, does the GDPR affect me or the client I provide the service to?
Presuming if it's your data breach, if your organization's the one that got breached, then yes, absolutely, you're in scope. Because if you're an MSSP, you're looking at the packets of EU data subjects, so you're processing personal data of folks there. You're offering a good or service to the EU. So yeah, you're absolutely in scope for GDPR.
Okay, next question. What is the difference between a legal basis for collecting PII and a business rationale, or are they the same?
They're basically the same. And by the way, it's personal data, not PII. Yeah, they're the same. Here's the difference, if you wanted to call it a difference at all, is that with a legal basis or legitimate interest, you're looking at two things. One is your interest, but you're also looking at how it affects the data subject. So what kind of benefit is it providing, or what kind of burden are they going to get if the data escapes? Again, I'm using the examples of Office of Personnel Management or Ashley Madison or credit reporting agencies. The stakes are very high. So if you use legitimate interest in those cases, you have to ask yourself, is what you're providing so valuable that it's not greatly outweighed by the risks to the data subject? And I think in those cases, you can make the argument that it was.
Great. So data classification is not required to be GDPR compliant. Is that correct?
Data classification is a tool for helping you get GDPR compliant. Data classification itself is not something that becomes compliant, but it is one of many tools that you would likely use, and I would hope you would use, to assemble your Article 30 data processing records. So no, it's not. Doesn't have to be compliant in and of itself, but it will hopefully get you compliant if you continue to invest in it.
Great. Next question: what data elements need to be anonymized?
Anything that is reasonably able to identify a person. So, for example, say that a social security number is a great example. That's something that would have to be absolutely disconnected from the data set because it's so radioactive. I'm sure that there's equivalents in the EU that have to be disconnected as well. Their version of a national insurance number or something like that. So you have to look at each data element in and of itself and ask, could this connect someone in and of itself or in a combination with a couple other elements? If so, then you're going to have to remove it in order to anonymize. There's all kinds of procedures on how to anonymize things that we have here. Health and Human Services has a great guide on that. And you can apply those principles presumably to anything.
Great. Scott, we're at the top of the hour. If you don't mind spending a minute summarizing, that'd be great.
Sure. We've got about 60 days left on the clock here, and there's still a lot you can do. I talked earlier about establishing a data protection committee, very important going forward because you have to have someone that's going to govern how you address privacy and security as a unit in your organization. Establish your critical path. Okay, what are all the things you need to do? And the extension of which, or the delay of any one of which, is going to, by necessity, extend the whole project. So you establish that critical path. Include your work councils in on that because they're going to want to be briefed. They may even want to get an opportunity to approve what you're doing. Get your third parties on board. This is really a great opportunity to talk to your third parties, to find third parties. A lot of folks don't know who their third parties are. Go find them. Go find the contracts. Go talk to these folks. They're the weak link in the chain. You don't want them running amok with your data and getting you in trouble. And then organizational measures, things like policies and procedures are a great way to get compliant, and they're very necessary. They're also very cost effective. And then finally, start planning for phase 2. Everyone's working on phase 2 right now in the sense that they know that what they're doing right now is not 100%, and now we need to look at post May 25th. That's your phase 2. Start with your plan of action and milestones. Get that written, get it ready to go, because there's going to be a lot more post May 25th work needs to be done.
Thank you, everybody, for joining us. If we're unable to get to your questions, we'll answer them by email. We hope to see you at our future webinars. Thank you.